Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspectives of educational administrators and policymakers. This is episode 31. In this episode, I focus on a recent U.S. Supreme Court decision on public officials' use of social media. The question is, can public officials delete comments or block users who criticize them on social media? Although this case is about a city manager's social media use, its implications extend to all public officials, including those in the education sector. The United States has about 20 million state and local government employees, spanning a vast array of roles from governors, mayors, police chiefs to teachers, school board members, healthcare workers, and transportation officials. Many of them turn to social media for both personal and professional purposes, leading to a frequent overlap between the two. In the case of Lindke v. Freed, James Freed, who was a city manager in Michigan, had a Facebook page. Initially, he created a private profile and later converted into a public page. On his Facebook page, Freed described himself as daddy to Lucy, husband to Jesse, and the city manager, chief administrative officer for the citizens of Port Huron, Michigan. This description on Facebook is a clear illustration of how he intertwined his personal life with his professional role. This is consistent with how he used Facebook. Freed's use of Facebook blurred the lines between his private life and public duties as a city manager. On his personal side, Freed shared extensively about his life, posting hundreds of photos of his daughter, updates about family outings like dances and dinners, home improvement projects, and even Bible verses. His personal posts offered insights into his daily life, family, and personal interests, including pictures of his dog, Winston. As a public official, Freed also used Facebook for official purposes related to his role as city manager. He posted about city activities such as high school visits and major projects like the reconstruction of the city's boat launch. He shared official communications from other city departments like press releases from the fire chief and financial reports, and engage the public on city matters through posts soliciting feedback or sharing links to city's service. Freed's interaction with the public through his Facebook page further demonstrated the dual nature of his Facebook use. He often responded to comments, provided information, or clarified city policies in response to public inquiries. Freed also exercised control over his Facebook page by deleting comments and ultimately blocking users like Kevin Lindke, who criticized his or the city's handlings of issues such as the responses to the COVID-19 pandemic. Lindke sued Freed, alleging that Freed had violated his First Amendment rights by blocking him from commenting on the public forum. The Supreme Court reached a unanimous decision holding that a public official who prevents someone from commenting on the official's social media page engage in state action only if the officials both first possess actual authority to speak on the state's behalf on a particular matter, and second, purported to exercise that authority when speaking in the relevant social media posts. What does it mean? How does it relate to educational officials who also interact with the public on social media? Basically, the Supreme Court identified two essential conditions that must be met for public officials' use of social media to qualify as state action taken by government officials or entities. First, having public authority. The public official must have the actual authority to speak on behalf of the state or public entity on the specific matter being discussed on social media. This means the official's role must officially include the capacity to communicate on the topic. For example, a school principal discussing school policies or responding to comments about school events on their social media page may meet this criteria because such matters fall within the scope of school principal's professional duties. The second condition is a purported exercise of authority. The official must also demonstrate that they are exercising their authority in the context of social media interaction. This does not mean every post or comment must be an official declaration. The Supreme Court's opinion provided an example. Consider a hypothetical from the offline world. A school board president announces at a school board meeting that the school board has lifted pandemic-era restrictions on public schools. The next evening, at a backyard barbecue with friends whose children attend public schools, he shares that the school board has lifted the pandemic-era restrictions. The former is a scenario taken in his official capacity as a school board president. The latter is a private action taken in his personal capacity as a friend and a neighbor. While the substance of the announcement is the same, the context, an official meeting versus a private event, differs. He invoked his official authority only when he acted as a school board president. Let me provide another example. If a school principal uses his social media account to announce a snow day or respond to criticism of school policies, they are acting in their official capacity because they are addressing matters within their professional purview. The social media account could be viewed as a public forum related to their professional role. If so, suppressing speech, such as deleting comments or blocking users based on their viewpoints, could infringe on First Amendment rights. The First Amendment protects against government actions that suppress free speech, and the public officials, including educational administrators, may face legal constraints on their ability to censor speech in forums they have opened for public discourse. Here is another example. A school district superintendent uses his personal Twitter account to share updates about district policies, school closure, or educational programs. If this superintendent begins to block users who criticize those policies or ask challenging questions, the superintendent's action could be a violation of the critic's free speech rights. If the superintendent has the authority to make policy announcements, which meets the first condition of curbing actual authority, and the superintendent is using the Twitter account to do so, which meets the second condition of purported exercise of that authority, then blocking critics could potentially be seen as a violation of the First Amendment rights of the blocked users. However, if an educational official uses their social media account strictly for personal purposes, such as sharing family photos, discussing hobbies, or commenting on public events such as sport events or music festivals unrelated to their job, without blending it with their official duties, then blocking other social media users would not likely be considered state action taken by government officials or entities. The distinction lies in the nature of the authority and the context in which it is exercised on social media. What can educational administrators learn from this case? First and foremost, it's important to clarify on your social media profile page whether it is being used as a personal account or a public account associated with your role as a public official. This distinction helps mitigate confusion among your followers regarding the capacity in which you are posting. You should also avoid the mingling of personal content with job-related content. This separation helps maintain the clarity of your role and the purposes of your communication on social media platforms. In the case I introduced today, Freed had a mixed use of Facebook, where his personal life and official duties were intertwined on the same social media account. If Freed had maintained separate accounts for his personal life and official duties, the differences between personal and state action would be clearer. On the personal account, actions like deleting comments or blocking users would typically fall outside the scope of the First Amendment because they would be considered not state actions taken by government officials or entities, but private actions not subject to constitutional constraints. On the other hand, on a public official account used to interact with the public on matters related to his role as a city manager, actions taken could be considered as state actions carried out by the government. In such contexts, deleting comments or blocking users because of their viewpoints could potentially violate their free speech rights under the First Amendment, assuming the social media account function as a type of public forum. As Justice Amy Coney Barrett wrote, a public official who fails to keep personal posts in a clearly designated personal account therefore exposes himself to greater potential liability. Third, in addition to further separating your personal and professional use of social media, you can also add a label or disclaimer. On your personal social media, you can state, "This is the personal page of Zhong Dou or Jane Doe," or "The views expressed are strictly my own." On your public social media account, you can make it clear that this account belongs to a public entity, such as the official account of the State Department of Education or ABC School District or XYZ School. Those clear declarations help set the right expectations for your audiences and reinforce the boundary between your personal views and professional duties. Moreover, those labels and disclaimers can serve as a protective measure, defining the scope of your engagement on social media platforms and potentially shielding you from legal challenges related to free speech issues. Here is another case about an education official's use of social media. In this case, Michelle O'Connor Radcliffe and T.J. Zane were elected to the Poway Unified School District Board of Trustees. They use social media to communicate with constituents and promote school district-related content. They had public Facebook pages, and O'Connor Radcliffe also had a public Twitter page, both of which were used to share the information about the school district activities, board meetings, and solicit public feedback. Those pages were marked with their official titles, indicating their role as government officials. Christopher and Kimberly Garnier were parents of children attending the schools in the district. The parents frequently criticize the school board on social media platforms. Their comments, often lengthy and repetitive, led the school board trustees to initially delete their comment and subsequently block them from commenting further. The parents filed a lawsuit claiming that their First Amendment rights were violated when they were blocked from commenting on the trustees' social media pages. The U.S. Supreme Court redirected the lower court to re-examine the case using the reasoning and the two standards I introduced in this video. What do you think the court will rule in this case? Feel free to share your comments below.